Welcome back F4. In this video, we will discuss the civil law system. Common law. The common law is the body of law formed through court decisions, as opposed to law formed through statutes or written legislation. A common law system is the system of jurisprudence that is based on the doctrine of judicial precedent, the principle under which the lower courts must follow the decisions of the higher courts, rather than on statutory laws. The common law legal system originated in England, was later adopted in the United States and Canada, and is in place in most Commonwealth countries. While the English common law system has its roots in the 11th century, the present system has evolved over the past 350 years, with judges chasing their decisions on those made by predecessors. Sources of common law. Common law and equity. Common law is based upon merging local customary laws into law of the land. Remedies under common law are monetary, such as damages. The concepts of equity developed in later years, which were based on fairness. Equity steps in whenever monetary compensation is not an adequate remedy. Specific performance, injunction, rescission are the main equitable remedies. Whenever there is a conflict between common law and equity, then equitable principles would prevail. Statute. This is law produced through the parliamentary system. It upholds the doctrine of parliamentary sovereignty within the United Kingdom, means that Parliament is the ultimate source of law and, at least in theory, it can make whatever laws it wishes. C. Customs. Local customs also act as a source of law. D. European Union law. Since joining the European Community, now the European Union, the United Kingdom and its citizens have become subject to European Union law in areas where it is applicable. European law supersedes any existing United Kingdom law to the contrary. Doctrine of judicial precedent. Case law is judge-made law which consists of decisions of the courts. Once a legal principle is decided, it is known as a judicial precedent. Doctrine of judicial precedent. This means that the judge is bound to apply a decision from an earlier case to the facts before him. This doctrine is known as stare decisis. Judicial precedent can only be considered as a binding precedent if it is a ratio decidendi. The ratio decidendi of a case may be understood as the statement of the law applied in deciding the legal problem raised by the facts before a judge. B. The material facts are similar. C. Decision must have been by a superior court. Statutory interpretation. It is the process of interpreting and applying legislation. In most cases, there is some ambiguity or vagueness in the words of the statute that must be resolved by the judge. To find the meanings of statutes, judges use various tools and methods of statutory interpretation. There are techniques of statutory interpretation. Literal rule is a type of statutory interpretation which dictates that acts are to be interpreted using the ordinary meaning of the language of the act. Purpose approach is a theory of statutory interpretation that suggests that courts should interpret legislation in light of the purpose behind the legislation, keeping in view the ordinary, literal and grammatical sense of the words. Contextual rule. Words in statute should be interpreted keeping in view their context. Presumptions of statutory interpretation. Statute do not override existing law. B. Statute does not alter existing common law. C. Statute is not intended to deprive a person of his liberty. D. Statute does not have a retrospective effect. E. Statute does not bind the crown. Civil law system. The civil law system is a codified system of law. It takes its origins from Roman law. Features of a civil law system include: there is generally a written constitution based on specific codes, e.g., civil code, codes covering corporate law, administrative law, tax law and constitutional law, protecting basic rights and duties. Administrative law is, however, usually less codified, and administrative court judges tend to behave more like common law judges. Only legislative enactments are considered binding for all. There is little scope for judge-made law in civil, criminal and commercial courts. Although in practice judges tend to follow previous judicial decisions, constitutional and administrative courts can nullify laws and regulations, and their decisions in such cases are binding for all. A civil law system is generally more prescriptive than a common law system. However, a government will still need to consider whether specific legislation is required to either limit the scope of a certain restriction to allow a successful infrastructure project, or may require specific legislation for a sector. If this video is helpful for you, then please like and subscribe. In the next video, we will learn international trade, legal regulations and conflict of laws.